very happy to answer your questions.
Thank you very much, Mr. Paulson. Now, we will begin with the question period. Each member in turn will have 5 minutes, of course, and I will begin. As you can see, put the document up on the screen, Mr. Lewis of Bank of America claimed under oath to Attorney General Cuomo's office that he would have renegotiated the deal if you didn't tell him he could not do so. A lawyer says to Mr. Lewis, you can always renegotiate. Mr. Lewis says, not when you're told you cannot do it. Mr. Lewis is asked, would you have tried to renegotiate the price if you weren't told not to do it by Mr. Paulson? Mr. Lewis's answer to that is yes. Is it true then, Mr. Paulson, that you told Mr. Lewis he could not renegotiate the Merrill deal?
Well, it wasn't quite that direct or specific, but I can be very clear that we viewed the invocation of a MAC clause, whether it was to renegotiate or just get out of the merger, as being very risky. The markets were driven by fear and uncertainty, and an invocation of a MAC clause, whether it was ultimately going to be resolved by the courts or be resolved by a renegotiation and a shareholder vote, would lead to an extended and difficult process. And the fact still remained that we viewed the MAC clause as being a legally binding contract.
Was that a yes?
Well, that was what I said. I said that we viewed, I viewed, and I know the Fed viewed, that the invocation of a MAC clause would be a serious mistake. It would be a colossal lack of judgment if he invoked the MAC clause, whether it was to renegotiate or whether it was to go through the courts.
I'm still trying to find out whether that was a yes or no.
Well,
and maybe it's not allowed.
Did I order him directly? It wasn't that direct, but I did say that I thought invoking the MAC clause would be a colossal lack of judgment. There was no sound legal basis for it, and the distinction between invoking the MAC clause to renegotiate or go to the courts was one that, for all practical purposes, was not a significant one.
Well, let me say, if he had issued an indicated fact that the MAC clause, that he wouldn't that be a colossal lack of judgment on his part? And wouldn't this have jeopardized his own bank and the American economy if he exercised the MAC?
Yes. Yes, Mr. Chairman. It was a view of very experienced Federal Reserve lawyers that there wasn't a sound legal basis, and it is my understanding that there is no instance where a Delaware court has let a company use a MAC clause to get out of a merger. And this particular MAC clause even had a carve-out which carved out changes due to market conditions.
My concern is that if you had those concerns, you know, why didn't you just fire him?
Well, I would say this. Remember, Mr. Lewis did not invoke the MAC clause. He did not do something that caused a colossal, that showed a colossal lack of judgment. Mr. Lewis was considering this, and his board was considering this, and they decided to fulfill their contract and acquire Merrill Lynch.
Yeah. Well, you know, it seemed to me that if he has this lack of judgment, I mean, how could you give him $20 billion? Seemed to me you would have just forced his hand at that point in time and pushed him out.
Mr. Chairman, I'm making a distinction between an action that he might have taken, which he didn't take. If he had taken an action that showed a lack of judgment, I think then the regulator would have been irresponsible if the regulator didn't push him out. But he did not take that action, and they fulfilled their contract and they acquired Merrill Lynch.
I'm running out of time here. Did you call Mr. Lewis, or did he call you in reference to this deal?
In which of these calls?
I'm telling you, is it true that Mr. Lewis called you in December 2008 and asked the government to get involved in the Merrill Lynch deal, or did you call him?
No, the first time we heard of this was a call from Lewis. And so on December 17th, I heard from a member of my staff that he would be calling, and then I got a call from him, and he said that he and his board were concerned to learn of the extent of Merrill losses, which he'd become aware of very recently.
Yeah. Well, my time has expired, but let me just ask you this before we run to the. Is it true that Bank of America first brought up the bailout? Did they bring up the bailout to you, or did you bring up the bailout to them?
Well, Bank of America came to us with their concerns about their losses and their concerns about going ahead with the acquisition. And in terms of the bailout, I prefer to use the word rescue, but whatever word we use, that this came out of discussions because we had very much, at least I think we had an alignment of interest, because my concern was the American people. And I took a look at the losses that I heard coming as being breathtaking.
Pull the mic just a little closer to you. Pull the mic a little closer to you. Pull the mic a little closer to you.
Oh, I'm sorry. So as I said, the rescue came out of discussions, and I believe it was the view of the government, the Fed and Treasury, that when these announcements were announced, that they would truly shake the market were it not for some form of government support being in place. And so we felt that we needed that in place in order to keep the system intact.
Yeah. Well, let me just say we'll continue to